Representing children in cases involving domestic violence. Professor Breger is a family law professor at Albany Law School, where she's taught since 2002. As Betsy indicated earlier, we have a speaker bio with a tremendous amount of detail relative to all of our speakers' qualifications and experience. What's particularly noteworthy is that Professor Breger was for 8 of her years at the law school, director of the Family Violence Litigation Clinic, which I was a part of when I attended Albany Law School. I think that's what really propelled me into family law, and I think it's probably the best training ground to get your hands-on experience in family court prior to actually being admitted and out there representing various individuals in proceedings. I also want to mention that Professor Breger devotes a tremendous amount of her time to our office, to our program. She's a member of our advisory committee, which is the committee that really oversees our program. She's also a member of our curriculum development committee, helping us formulate training ideas for purposes of presenting CLEs for all of you that are particularly helpful to your family law practice. So without further ado, I'm going to ask you all to welcome Professor Melissa Breger.
So, good morning again. Let me go ahead and start us on our first clip. So, just to start off, it's important to think about why is it so critical for an attorney for the child to understand the dynamics of intimate partner violence and coercive control. Why is it important to know the laws in terms of domestic violence? And generally, why do we need to know about domestic violence? Many of you might know that New York State now requires attorneys for children to learn about domestic violence dynamics. Obviously, this 1 hour will not be everything you need to know, but I'll do my best to talk in broad strokes. Just so we're on the same page in terms of terminology, when I'm speaking about domestic violence, intimate partner violence, I'm talking about a pattern of coercive tactics, which can include physical, sexual, economic, emotional abuse perpetrated by one partner against another partner, former or current, with the goal of establishing and maintaining power and control over that person, what we call a pattern of coercive control. So that we're sort of on the same page. And there are dynamics that are part of domestic violence that may not fit squarely into the enumerated family offenses, and may not even be a crime, but still are part of that pattern of one person trying to control another. Beyond the fact that the state requires you to learn this, there's also some other things that are important. Custody and visitation disputes are more frequent when there's a history of domestic violence. In fact, abusers are 2 times more likely to seek sole custody when compared to nonviolent parents, and are more likely to misuse the legal system as a way to continue the abuse. So essentially, the abusers are often using the legal system as one of the tools of power and control. So because we know that to be the case, we need to be aware of that. And it also just intersects with so many parts of family court, so you would come up with that. So again, in 1 hour, I can only scratch the surface. This is something I could have a whole semester about. So I'm going to briefly cover dynamics of domestic violence and the effects of domestic violence upon children, which is required. But the Office of Attorneys for Children also has additional videos for you to more fully familiarize yourself with the importance of the topic. You do earn CLE for it, and the website is here. This is the 3rd department. I imagine 4th department has one as well. And so I would really urge you to complete those trainings as well. This will be on the website as well, but obviously not helpful for you since you're here, right? But I can't emphasize enough how important it is to understand this. When we're representing children in family court, in a variety of proceedings, if you don't understand the kind of complex and nuanced dynamics of domestic violence, you really could be missing something very big. And so in my mind, not learning these basic things is really just tantamount to not fulfilling your role as attorney for the child. So I really would urge you to go ahead and look at what training is there. and go from there. So let's do some basic review. Everybody knows the answer to this, hopefully in the room. What's the legal standard for custody and visitation? We know it's best interest, but probably not one of us could define precisely what that means, right? It's this very amorphous standard, it's complicated. And as you might know, in the state of New York, it's mostly defined by case law. There are states, like Michigan, for example, that actually list them all out in the statute, but not New York. It's mostly case law. So that's a little bit harder for you to wade through. The types of things, and I know you know this already, but the types of things that courts will look at when we look at best interest factors are things like who's the primary caretaker? What does the child want to go? Are there special needs? Are there access to siblings? All sorts of things like that. But again, this is case law. And what's unique is domestic violence. Domestic violence as a best interest factor in custody and visitation cases is the only codified factor in New York. It's the only factor that is actually written as part of the statute that courts must consider, and if not, could be overturned. Okay, must be considered. So it's unique in that regard that in the state of New York, it's the only one that's right in the statute. Everything else is case law. Okay, and when we talk about family violence, they're talking about that intimate partner violence that I was describing, that coercive control, but certainly courts will consider child abuse and neglect and other kinds of family violence in the home as part, when issuing custody and visitation. So certainly it's not just intimate partner violence. Courts will look at a whole host of things when determining custody. So let's just review the law, which many of you know and practice, but as a refresher. We look at Family Court Act Article 6, and then we look at domestic relations law. There's a few new updates that I kind of noted. For example, 651E3 that says that before a judge can even issue a custody or visitation order or a modification, the judge has to check the registry for a CPS history, criminal history, orders of protection, and so on. And then it also is the same thing that requires this. And then domestic relations law, which we'll talk about. But another law that's really important in all of your cases, and I know it's kind of difficult to see my small writing here, but let me read it to you, is Rule 7.2, right? 7.2 plays into these as well. The attorney for the child must zealously advocate the child's position. One, in ascertaining the child's position, the attorney for the child must consult with and advise the child to the extent of and in a manner consistent with the child's capacities and have a thorough knowledge of the child's circumstances. Two, if the child is capable of knowing voluntarily and considered judgment, the attorney should be directed by the wishes of the child, even if the attorney for the child believes that what the child wants is not in the child's best interests. That's the important part. Obviously, the attorney for the child, and I'm reading from the rule here, should explain fully the options available and may recommend to the child a course of action that in the attorney's view would best promote the child's interests. But in the final analysis, we are representing what the child wishes. Now, there is an escape clause, right? We know about the fact that, if we do not believe the child has the capacity for knowing and voluntarily judgment, or there's a substantial risk of harm, there are exceptions, right? But for the most part, we have to think of that. But still, the attorney for the child has to convey and articulate the wishes of the child to the court. So we have to keep that in the back of our mind. Again, back to 240. If there's a finding or conviction by at least a preponderance, the court must take it into account. And that is really a must. We are going to talk about some cases in which courts have been overturned by the appellate divisions because they did not do so thoroughly. And keep in mind that when we talk about a finding or a conviction, a consenting to an order of protection is not counting. That doesn't count. So if a batterer says, well, I'll just consent to an order of protection, let's work it out there, that does not count here. It has to be an admission or a finding after trial. So one thing to keep in mind when you're working on settlement negotiations is that you don't want just that consent, because this really hooks the court into having to consider the factors here. Okay. The family offenses that are included in Family Court Act Article 8 are what is considered, but really any crime of domestic violence would count. So certainly there's the designated offenses, but there are plenty of other criminal convictions that fall outside that would count under 240. Now, taking a step back, in order to have had domestic relations law 240, there was extensive work done on those who were trying to push for that legislation. And there were just piles and piles of papers and data and studies to show the injurious effects of domestic violence upon children, even if the children themselves were not injured or were not part of the situation. So what I mean by that is we were finding, studies were finding that if there's domestic violence in the home, that can be very, very damaging to children, even if maybe they're not aware of what's going on, or maybe even if they're not part of the actual fight. Now, there's physical dangers to children, even if they're not kind of part of the interaction. They could be caught in the crossfire. They can intervene when they become teenagers, right? They want to sort of protect the other parent. They can be, maybe as a baby being held in the arms of a parent. There's all sorts of ways that they're physically can be in danger, even if they're not physically being attacked. But it's really more the psychological effects that we worry about. There is a tremendous nexus between domestic violence and children, even before children are born. So in utero, many times victims of domestic violence who are pregnant will either miscarry or have very low birth weight babies. For me, the most startling connection is that oftentimes domestic violence either starts or intensifies at the time of pregnancy. And so for whatever reason, that is a trigger for violence. And studies show that more pregnant women die from murder by an intimate partner than from pregnancy-related complications. Pregnant women who are murdered also experience very violent deaths. They are most commonly shot, stabbed, or strangled. So there's that connection early on, before the baby's even born, which is always startling. Once the child is actually in the home, then all kinds of things can come up. These are the types of things: post-traumatic stress, chronic abdominal pains, chronic headaches, anxiety, depression, social withdrawal, excessive clinging behaviors, enuresis and ecropesis. That's basically a child soiling himself or herself when they're at school age. They're already potty trained. Bedwetting, poor academic performance, suicidal ideation. The list goes on. Some mental health professionals would say that children in domestic violence households are not unlike children in war-torn countries. They're always at risk, they're always at danger, and they have no controls over their environment or their safety. Other studies show that childhood exposure to domestic violence is one of the most consistent risk markers for battering. And this, for whatever reason, is very gendered. You find that little girls in the homes that are where there's domestic violence tend to grow up more often to be victims, and little boys in the home tend to more often grow up as batterers. That's what the studies have shown. Okay. So I think I've convinced you, and you may be wondering, well, why doesn't the conversation just end there? Why can't we just say, it's bad for children to be in these homes, let's just make we have these laws in place, let's do it. Well, again, the practice in the courts is not always consistent, because we have 240 on the books, and 240 has been on the books for a long time, that courts must consider domestic violence, any domestic violence in the home. And yet you have significant cases where that hasn't been done. So the most significant case, well, I shouldn't say the most significant case, a very powerfully worded case is the Wissing case. Have any of you read it or are familiar with it? Okay, so I'll go into it a little more detail. I mean, it's nothing out of the ordinary in terms, I mean, it's just a second department case from 2002. But the wording is so powerful and so important because it really is the second department saying to the trial court, you didn't do enough here. You didn't look into this enough. So I'll give you some of the details. And it just gave a little bit more teeth to the statute that already existed. So in that case, the appellate court said that the trial court did not entirely ignore the legislative mandate. And in fact, the court specifically considered the effect of domestic violence, but the consideration afforded the effect of domestic violence was, quote, sorely inadequate. The court said, were it not for the documented history of domestic violence confirmed by the court after a hearing, we would have unanimously affirmed the family court's award of custody to the father, as that was what Andrea's expressed preference was. So this was a teenager who says, I want to live with the father. The father was the abuser in this case, and the court was also hearing the family offense case and had just heard the testimony. The fact of domestic violence should have been considered more than superficially, particularly in this case where Andrea expressed her unequivocal preference for the abuser while denying the very existence of the domestic violence that the court just found she witnessed. Right? So they had just heard in Article 8 where she's in the middle of all of these situations, and then when she gets on the stand, she says, or when she's talking to her attorney, she says, no, there's no domestic violence. Court goes on. The record is replete with incidents of domestic violence reported by the mother and by evidence supporting her testimony. The earliest incident that the mother reported was perpetrated when Andrea was merely an infant in 1986. In a fit of anger, the father hit and kicked the mother, pulled out chunks of her hair. In the course of the attack, she heard him say, "Oh well, she's going to die." On Super Bowl Sunday in 1995, the abuser attacked the mother again, throwing her on the floor, kicking, hitting, and choking her. She sustained marks on her neck and a sore throat, causing pain while speaking and inhibiting her ability to swallow. That March in 1995, she obtained an order of protection from the Village Court of Montgomery. In the fall of that year, the father held a knife approximately 8 to 10 inches long to the mother's throat while Andrea, then 9 years old, sat in her mother's lap. In February 96, the mother again obtained an order of protection. In 1997, the father attacked the mother, hit and kicked her, resulting in her obtaining a permanent order of protection. The severity of her injuries are documented by photographs entered into evidence showing large black and blue bruises on her left hip. In June 99, the mother left the marital home with Andrea. She moved into a shelter where they remained for 5 days. Upon their return home, the father blocked the car in the driveway, yelled at the mother, and punched her. On June 24th, 1999, a few days after Andrea and the mother had returned from the shelter, during a dispute over tax returns, the father tried to wrest papers that the mother held in her teeth. By squeezing her face in his hands, leaving marks, and then asked Andrea, then a teenager, for assistance, asking her to please hold your mother's nose so she will be unable to breathe. Then in December of 99, while Andrea was at home, the father attacked the mom, strangling her, leaving marks on her neck for days. So that's just a smattering of the kinds of things that were going on, but the child was clearly present during many of these. So in this case, this is the appellate court talking again. In this case, the family court did not entirely ignore the mandate, but again, it did not consider it, did not afford it the due weight it deserved. In a case like this, there should have been more. If a child was expressing her unequivocal preference for the abuser, perhaps they should have ordered a comprehensive psychological evaluation. Such an evaluation would likely include a clinical evaluation, psych testing, review of records, information from collateral sources. In this case, the forensic evaluator could look into issues of nature of psychopathology of the abuser and the victim, whether the child might be in danger of becoming a future victim, the child's developmental needs, given the fact that she has lived in, this is the appellate division, polluted environment, all of these things. But instead, the court just ordered one of these 1-hour forensics, and that was all that was done. So the appellate court was reprimanding of the court for that as well, and said the child learns a dangerous and morally depraved lesson that abusive behavior is not only acceptable, but may even be rewarded. Okay, so again, it's one case, but the DRL 240 had been on the books for years, and to think that in 2002, courts were just really kind of glossing over it, the appellate division wanted to send a strong warning to say, that's not enough. If you have a child who is saying, I want to be with father, of course, as AFCs, we want to honor that. We just talked about wanting to honor the expressed wishes. But yes, sometimes need to dig a little deeper and go beyond the scenes, because obviously the attorney for the child, having been there at the other hearing, had heard these things too. You might want to say, how do you reconcile the fact that I heard, you were in your mom's arms when there was a knife held to your throat or whatnot. So the cursory nature of the forensic and the cursory nature of the attorney for the child just adopting the child's views without digging deeper was not acceptable. Okay. And it, it goes on and talks about a lot of the literature and so on. So, it's just a very well-worded case. So that might be confusing. I just read you 7.2. You're saying, well, what about that? I mean, it's a teenager. Teenagers have their own beliefs, and the teenager wants to live with the father, was clear about that. Who are we to say no? And so again, 7.2 still applies and governs, but we just have to keep in mind that in addition to being that attorney, part of our attorney role is counselor at law. And so you can counsel your client and you can say to your client, I understand that at 14, I believe she was 14 at the time of the trial, 16 by the time the appellate division came out. So she's 14, you can say to her, I understand, Andrea, that you want to live with your father, and I will let the court know that. But I have some concerns when I hear about some of the things that have happened. How does that work? When you say there's no domestic violence in the home at all, how is that, what's going on here? Or whatever it may be, okay? But that's tricky. And Wissink is a really tricky case because on one hand you're saying, I want to represent the child's expressed wishes. I've been told that's my job, but I'm a little concerned for my child. For my client, rather. And what is really my role? So again, often folks will say you're the voice, but you don't have to parrot everything that the child is saying. And you're still the mouthpiece, but you might really delve further into what's really going on. This is true for Article 10 cases as well. Children always want to live with their parents, and you might find in an Article 10 case that there's horrific neglect or abuse going on in the home, and the question becomes, well, what's your role as the attorney for the child when you personally are concerned about sex abuse in the home or whatever it may be? And it's very tricky. There's a lot of sleepless nights, right, for those who've already been there. In the final analysis, we would say the attorney is merely one voice, and there's also caseworkers, and there's also parent attorneys. And so the judge will get a full look at everybody's view, but it's important to at least convey the voice of the child, because otherwise the child is silenced. And we don't want to substitute our own judgment for what we think is best in a particular home. We want to honor that the child is the one living there. But it is a balancing. Many children will say that if their attorney wasn't going to listen to them anyway, they'd rather not have an attorney at all. Right? So we have to be mindful that, we do want to express that choice and we do want to articulate that choice, but that there's a lot that can happen behind the scenes before we get to that point at court where we can really talk to our client about what's really going on. Okay. Believe it or not, in 2009 there was additional legislation. Folks were finding there still just wasn't enough teeth in 240. It's like, well, we must consider it. It's the only one we must consider, but still courts weren't doing it. So then Governor Patterson signed into legislation that you have to be explicit about your findings, you meaning the family court judge. So the family court judge can't just say, I consider domestic violence and here's my answer, but has to say explicitly how it was considered and write that as part of the opinion, and that appellate courts were requiring that as well. So they must be explicit into how domestic violence was considered and how it was incorporated into the orders here. I'm going to stop for a minute and just see if there's any questions so far. Okay, I'll keep going then. How else can you protect and advocate for clients in an Article 6 case? Well, there's lots of ways that even once custody and visitation has been resolved, that the abuser can still be using power and control in the cases, right? So, for example, batterers might not return the child at the specified time, or not make the child available. You know, pickups at 5. Well, she's not ready. Come back at 6, or whatever it may be. They may skip a visit to just kind of punish the custodial parent. You know, we can't force parents to visit with their own children, but they might, you know, there may be some, you know, gamemanship going on here. I mean, in some cases, a child may be actually kidnapped. Some batterers might have other folks present that they're not allowed to have present, or use substances, or engage in illegal, inappropriate behavior. Any kind of interference with custody and visitation is just another way to control the other parent. So it's important as attorneys for the children to try to make orders that are as clear and specific as possible, creative, client-centered. Sometimes that's something that would have a clause that would say, if the other parent has, you know, it wants to exercise his or her visitation at 6 o'clock, that parent has to text or call at 5 and confirm. Because so many times you have your kid waiting there, waiting for the visits, and then sure enough, the abuser is not coming as a kind of a way of getting back at the parent. Vice versa, if there's going to be a change in visitation or timing or custody, that needs to be notified. Being as specific and clear as you can ahead of time about holidays. You know, that's where a lot of issues come up with custody cases, and so being, you know, having some of that already, you know, worked out, and the AFC absolutely has a role in that. I mean, it's not just the role for the parent's attorney. The AFC can weigh in and chime in and say, hey, let's think about where this can come in as well. Okay. Now, I mentioned forensic in the Wissing case, and I know that I think you're having a session on forensics. I just wanted to say briefly that, you know, there is some bit of a role in the forensics for the attorney for the child. As we know, these forensic reports often come into evidence as the court's exhibits, so kids may have access to them at some point, or parents might have access to them. It's important to let the kids know that, you know, that what you're telling the forensic, you know, that person's not your lawyer. He or she doesn't have confidentiality with you. And if you tell her something, she's going to put it in a report. She doesn't have that privilege. And so the court might hear what you're telling her, and the parents might hear what you're telling her. And that's an important thing to let your client know. The client does not have the same relationship as an attorney-client privilege. It also might be helpful to debrief clients after the evaluations are completed to let kids know about any damaging things that might come out, depending on their age, of course. I mean, more teenagers than young kids. And to really take a critical eye to the forensics and to look at those psychologicals, and did the psychologist take into account the child's views, or did they just kind of substitute their own judgment as to what they think is best based upon which parent they liked better? That's not acceptable. In New York, judges cannot abdicate their role to forensic evaluators, so you cannot say, well, the evaluator said we're going to go to dad, so that's what I'm going to do. They have to have their own independent judgment there and can't just defer. So we have to make sure that forensics are fair and take into account children's positions as well, and that the forensic evaluator has a true understanding of domestic violence, not just, that it's only this or it's only that, but understands that kind of coercive pattern and showing that they understand that and they're not just kind of being swayed by the abuser or charmed by the abuser in a way that would, sway their opinion. What are some other important issues that come up when it comes to domestic violence in family court? UCCJEA, which is a tongue twister, Uniform Child Custody Jurisdiction Enforcement Act, I believe. Did I get that right? Okay. All right. So there is a clause in there about emergency jurisdiction. With UCCJEA, it's really more of a jurisdictional issue. It's that state A and state B have to talk and figure out who has jurisdiction. And so typically what will happen is they're going to require that, where's the home state? Who's lived there for 6 months? Well, in domestic violence situations, you often have a parent fleeing. So maybe you have a parent in Massachusetts who flees to New York with a child. Well, who governs, New York or Massachusetts, right? So there's this one clause that kind of talks about when that comes up. And then we'll talk about Tropea v. Tropea in a minute, and Nicholson, which are both really critical cases as well. Again, any questions before I move on? And I'm throwing a lot at you. It's early, I know. You're not thinking, you need more coffee before you can have questions. Okay. All right, so let's talk about Tropea. New York previously had the strictest relocation test of any other state in the United States. But it's since been relaxed by Tropea, where the courts use a balancing test when they're thinking about relocation. So relocation is a type of modification, right? One parent comes in and says, I would like to relocate. And it used to be nearly impossible in New York. But Tropea said there's more of a balancing act, and we look at these various factors. And in doing so, they can look at domestic violence. They can look at the reason why the parents want to leave. But these are the factors that would come up. The impact of the move on the relationship between the child and the non-custodial parent, right? So if you want to move your child to Florida, how's dad going to see the child, right? So what's the impact of the move? The reasons for the move. Are you moving because of violence in the home? Are you moving because you got accepted to a graduate program and that's the only place where you can go, and so on? The courts will look at that. The courts will look at the feasibility and desirability of a change in custody. Oftentimes what you're asking for in terms of the modification is you're asking for a change of custody and a relocation at the same time. The courts will look at the quality of lifestyle the child will experience in the new location. Many times children will be going to another state, but that may be really good for the child. There's maybe extended family there, better opportunities at school. The courts will look at each parent's good faith. Is this a relocation request based upon good faith rather than a vendetta? I'm not just moving to Florida because I want to get away from you, but I'm moving there because it's a better life for our child. The courts will look at the possibility of developing a visitation schedule for the non-custodial parent. I would always advise clients if I represented a parent, to have that figured out before you even file for relocation. Have it figured out where you say, I am going to say you get summers and you get winter break and you get 3 days during this break, and we're going to Skype twice a week, or have a lot of that already in your application, because what you're asking the court to do is essentially really curtail the visitation of the other parent, and so you want to do so in a way that seems fair and that's best for the child. But ultimately it is a balancing test, and that's how the courts will look at it. So you may also wonder, how does this all intersect with Article 10 child neglect cases? This is what gets really tricky. I've been focusing primarily on Article 6 cases, custody visitation, talked a little bit about Article 8, but when it comes to Article 10, child abuse and neglect cases, when the government has actually come into the family, dynamics change, and domestic violence plays a very important role there as well. Now, all that stuff I told you about, remember I said how domestic violence is so harmful for children, even if the children are not physically injured, but if they're just in the room or in the house, how damaging that can be. Well, the child protection workers in New York City, ACS, Administration for Children's Services, took that to heart and started to say, all right, well, whenever we see domestic violence, we're going to yank the kid, because that's just not a good home. And so it's, for all the reasons I listed, all those traumatic symptoms that a child can endure, we're going to just yank the kids. And so there's a mechanism in the Family Court Act where you can do so without court order and an emergency. And so this was happening with regularity, where ACS workers were coming into homes and just based upon any domestic violence at all in the home, minor or not, kids there or not, literally they were pulling kids into foster care. And so the class action started. It was heard by the Court of Appeals in 2004. I don't know when the class action started. Class action started with a group of New York City mothers. All of these mothers had been victims of domestic violence, but had protected their child or children as best they could. In fact, the named plaintiff, Charlene Nicholson, her incident happened. She was separated from the abuser. She had no relationship with the abuser whatsoever. He broke into her apartment, so that is not something she could have controlled. Her son was in school when it happened, and her baby was sleeping when it happened. And he did beat her, but again, the son was not there, and the little girl was sleeping, and she didn't invite him into her home. He broke in. Her children were removed in the middle of the night and placed into stranger foster care for, I believe, years, because the idea was that that home was no longer safe. Okay, but she wasn't with him, right? And those were the types of plaintiffs, that were in the class action. Each of them had situations like that. So now they sue, and they sue the state, the city, everything, the ACS, and they say, well, we understand that domestic violence is not good, but we also don't think it's good that you're removing children from their custodial parent just because that child is a victim. That mother is a victim. In all of these cases, it was mothers. And the lead counsel in that case, Jill Zuccardi, said, well, women have to be worried that either the abuser will take away their child or the state will take away their child. One way or the other, someone's taking away their child. Okay, so this ended up being a very complicated case. I believe it's in the materials. I'm not sure. Okay. And it started in federal court, and it went to Judge Weinstein, and he wrote a 196-page opinion, which is not in your materials, but you're welcome to read it anytime. It's actually a brilliant decision. It's really well thought of, it was very thoughtful. And he basically heard a ton of expert testimony. He heard social science expert testimony and all sorts of things, and he ultimately decided that ACS had violated the rights of these parents for various reasons. What was interesting was that there was expert testimony, and one of the experts, Dr. Evan Stark, that said many of the same detrimental effects that occur when children are removed from the parents are those same effects I read you. Because it's the idea of trauma, right? Those are kind of traumatic effects. And so children react to trauma, whatever that trauma might be. And the trauma could be that they were removed from their mothers, right? You picture the baby who's sleeping soundly, and then there you go, never sees her mother again for a year. Or the kid who comes home from school having no idea what happened, and he's in foster care for a year. So that's traumatic. And so what Judge Weinstein tried to explain in his 196-page opinion was that some of the very things that we were trying to prevent from having children be exposed to, we made worse. And that we really have to balance the harms. It's not just one or the other. In fact, there were some interesting studies. One of them was a study, an English study that was quoted by Dr. Stark. And they cited a case that happened in England. And this was a situation where at the time there were bombings in London. And about half of the mothers in London, this was back during the war, half the mothers in London decide, I'm going to send my kids off to the countryside, to live with relatives and aunts and uncles so that they're not exposed to the bombing. So, about half mothers send their children off to relatives to live in the countryside without bombings. The other half stayed home. This was not intentional, but when social scientists saw this kind of split, decided to study those kids as adults. Who's more well-adjusted? What do you think? Who fared better? The ones who stayed...
Kids that stayed home.
The kids that stayed home. The kids that stayed home, bombs all around, never can be predicted, but the kids who stayed home in London did much better than those kids who were sent off to the countryside. And so obviously not a perfect example, but a really good reminder to the court, and that was raised, and a good reminder to the court, that it's all about balancing the harms. There's no right answer here, but certainly removing a child from the custodial parent is highly damaging as well, can be highly damaging as well. And so he went, the expert went into all of the types of things that happen. Removal may do more harm than good. He talked about how this is really especially true in domestic violence cases and also sex abuse cases, because the child starts to self-blame. The child feels like, well, what did I do wrong? Maybe if I had just intervened, or maybe if I had just stayed in my room, right? So there's a lot of that goes on. So as lawyers for children, we're constantly balancing the harms. Now, what ultimately happened was the case went to the Second Circuit, and the Second Circuit largely affirmed Judge Weinstein's findings, but felt that there were certain issues it didn't know because they were New York State focused. And so it's kind of a strange procedural animal. Then sent 3 questions to the Court of Appeals. So the Second Circuit still maintained the jurisdiction, but said, I'm going to send these three questions to the Court of Appeals and ask them to figure it out, and then come back to the Second Circuit. And one of those questions was, is a child witnessing neglect? Is a child witnessing domestic violence per se neglect? And the answer was a resounding no. No, it is not automatically neglect just because the child's in the home. And so the other question was, is there ever a time when that psychological harm, that emotional harm, necessitates removing from the home in the middle of the night, right? Do we need to have these emergency non-court ordered removals, or can we do this in a way where we wait the next day, go to court, and so on? And the third one had to do with, do we need particularized findings of trauma for each child, or is it just enough to say this is damaging? So the Court of Appeals, at that time, it's 2004, unanimous opinion by then Chief Justice Kaye, determined the answers to the questions. Essentially, no, it's not per se neglect. There are very few situations where the emotional risk is so high, but it must be so rare and so stringent that maybe something like the child's threatening suicide or threatening self-mutilation. It has to be something that extreme for you to remove the child in the middle of the night. And the third answer was, you don't need particularized findings, but we can just assume that children can be damaged. Sent it back to the Second Circuit. In doing so, these were the things that the Nicholson Court, okay, good, it's working. The Nicholson Court said. The Nicholson Court said, remember, in New York, our standard is, did the parent exercise a minimum degree of care? We're not saying perfect. We're not saying ideal. We're not even saying as good as I would do. We're saying minimum degree of care. And so when you're determining whether the nonviolent parent exercised this minimum degree of care, please think of these 7 things. Please look at these things and consider what really were the choices here. Were there risks to leaving? Oftentimes, batterers threaten to kill their victims at the time of leaving. Separation assault is very common and very dangerous. So maybe he or she wanted to leave but couldn't. What was the risk to staying? What were the risks to seeking assistance through governmental channels, right? I mean, it seems great to say just go to a shelter. That's just not always a reality. Could you increase the danger to yourself? Shelters are generally safe, but there's also a lot of risk that people know where shelters are, and so batterers end up showing up, there, right? So what were those risks? 4, what were the risks attendant to criminal prosecution? It's easy to say, just call 911 and call the police, but we know that unfortunately a lot of times with domestic violence cases, at most the guy's going to be in jail for a night, if even. And so is that really the best method if the next day the abuser is going to come home and say, why'd you call the police on me, right? So think about that in a real way. What are the risks attendant to relocation? There was a time when you really could go underground and relocate. Can anyone hide now with the internet? I mean, you could pretty much find anyone or anything, right? So can you really relocate? I mean, you literally have to change your name, change everything and go into hiding for your life. So is that something that is available? The court asks, trial courts, please look at the frequency and severity of the violence. Let's look at what's happening in the home. And then lastly, the resources and the options available to the mother, to the survivor and the children. This is really a lot of times about economics, right? If many of us might say, oh, we would go live with our mother or friends, or, that's not really an option for folks, especially the folks in this case who were all impoverished mothers living in New York City, and they really had no options of where else to live. Some of them were living in Section 8 housing, so that was the only way they could really be living. Okay, so what the Court of Appeals asks trial courts to do is to think about, this is complicated. This is not just so easy to say, yes, domestic violence is bad. Yes, domestic violence can hurt children. It's more than that. And you need to look at the complexities and the nuances of each case and look at the facts of each case in order to decide, really, did the mother in that case or the parent exercise a minimum degree of care? If you find that he or she did not, then that's neglect. But if she did, that's not neglect. And taking those children and putting them in foster care is going to be more damaging than if you had left the children in those homes. It then went back up to the Second Circuit, and all was good, but I think the case that you have in your materials is the Court of Appeals case by Judge Kay. So with that, we have talked about, it worked, okay. With that, we've talked about Article 6, Article 8, Article 10. We've talked about how it's so important to understand the dynamics of domestic violence, how it's important to recognize that even when there's homes with domestic violence, we have to think about what our child is really saying while still expressing wishes. What questions do you have? What cases are you struggling with now that maybe we can shed some light on? Yes.
And the Nicholson case that you were just talking about, I know that issue came up in my county quite a few times where there's domestic violence and the other parent didn't leave. What is a way that an attorney for a child would handle that, and how do you determine how many times is enough? I know it's a hard question, but it's something that I struggle with.
Yeah, it's a great question. I'm going to repeat it because I know they're videoing us. I'm going to repeat it, but it's a great question, and it's really what trial courts have been grappling with. So this gentleman is saying, well, what happens when the survivor of domestic violence doesn't leave? Or how many times, when's enough is enough? And when do we sort of draw that line? And that's really what we call this kind of post-Nicholson case law review that we're seeing. The courts will say, if you, the survivor, don't leave, and you're being beaten, let's say, every single day in front of the children, and you don't leave, and you don't go to shelter or call the police or call, and this happens on a regular basis. I mean, that can certainly be child neglect, and it even can be enough for termination of parental rights. So you've seen a lot of appellate cases where TPR is based solely on the fact that the parent is a victim, but that could not extricate herself from the situation, right? But there's that balance, right? And we know that it takes 2 to 5 times for a person to leave. So even though you might want to leave a situation, maybe economically you can't, or you still love the person, or whatever, you're scared, or whatever the reason is. So courts do look at that, And I think the question is that courts should, I mean, people will say courts should look at it more, the nuance. So I've seen some cases, appellate courts, which have said,
This is an important notice. Please at this time write down the following code. M E C B E 5715 must be entered on a certificate of continuing legal education in order for you to receive CLE credit. Please again make note of this code at this time. M E C B E 5715. Thank you.
she did relocate. They did get back together, but, she did protect the child, and they're saying that's not neglect. And then you've seen others where she got the order of protection, but then the very next day she let him back in the home, and then he beat her again, and the children were there, and that's not okay. So, courts are looking at that, but again, it's so hard, and it kind of goes back to that earlier slide of looking at the factors and kind of weighing that, right? Because every case is so different. Right after Nicholson, we were seeing still a lot of the knee-jerk responses and wondering, didn't you read Nicholson? But now that people know about Nicholson and caseworkers are trained on Nicholson and judges are trained on it, there seems to be a lot more thoughtfulness going into it. But you can't always get it right. You're a caseworker, you're making what you think is the best decision. And it's a hard one. So they look at all those factors. Did you seek help? Did you do these things? Did you try? And then, and was it in front of and they really look a lot about that frequency and severity. A lot of courts will focus on that. Is this happened once a year because he broke in? Or is this every day in front of the children? And then, she's in the hospital. Then that's something we can't ignore. Other questions? Or other cases that you're grappling with currently or have been thinking about, where you're just sort of trying to figure out, what do I do? Other questions in general? I know it's early. Yes.
When you're looking at the emotional state of the victim, right? Because if it's still abused, they don't know how to get out, Breger syndrome. How does that come into this?
Okay, so I'm going to repeat the question because I know, Betsy's telling me. Okay, so the question is, how does it come in with sort of a battered person syndrome where, there's almost kind of this pattern of a learned helplessness to some extent where, you essentially, the person wants to leave but can't. That plays in as well too. What's a little bit tricky is, so battered person syndrome is really helpful in criminal cases where, let's say, the person ultimately, kills the abuser or harms the abuser, and then they say, well, it was because she was battered and so on. It gets tricky when it gets turned on its head in family law cases, because then you're saying, well, if you're that helpless, how can you raise a child? So it can be used against women. Or survivors, I should say. I think it's a delicate balance. And again, I think it goes back to this gentleman's question, which is that each case is so, is so specific to the facts. And you look at what are the efforts. Is it that the person went to shelter 3 times and he found her all 3 times? Well, then that's not, then the option we're giving her is not very viable. Or is it that, whatever it may be. But, there is that piece to it, and it can be used both ways. I think I saw another hand up, and yes, and then yes.
I'm just having a little hard time with, if you have a client that wants to live with the abuser, like you were saying, advocating for their position or just stating their position and kind of advocating for something else. I don't really know how that really works.
Right. Okay. So the question is basically sort of like with the Wissing case. We're telling you 7.2. You have to actually, advocate for, articulate your client's wishes, but at the same time we're saying, but don't just take it at face value and be a parrot, right? And so how do you balance that? So with Wissing, the court felt that the AFC didn't do what the AFC needed to do. The AFC, ultimately found that the trial court didn't look at it as carefully. In other words, just saying my client would like to live with the abuser and does not believe there's been domestic violence, that in and of itself, you certainly are articulating the view, but the court knows there's something else going on. So ultimately, the court should have ordered a psychological or whatever it may be, and not put the whole burden on the attorney.
But in that case, there was other evidence in the court that was proven. What if there isn't?
And that's the tricky part, because we're not in the homes, and we can only go by what our clients are telling us, and we have this relationship with our clients, and so we don't want to, so it's a judgment call. I mean, ultimately, articulating the wishes of the child is half the battle, so if you've at least done that, you've fulfilled 7.2. If you truly believe that child is in danger, then there's always the escape clause in 7.2. But also, there's a lot that goes on behind the scenes. So you shouldn't just be seeing your client the day of court in the hallway and saying, okay, what do you want to do, right? You would know your client, you would be speaking to her or him, and you would know they're conflicted. And so that you could counsel them as well. So there's nothing wrong with saying, I understand your position, and I will tell the judge you want to be with father no matter what. But can we talk about some things that are concerning me here, which is that you've missed this much school, and your mom's been in the hospital this much, and and you're telling me there's no domestic violence, but let's go there, and talking to collateral sources and so on. So it is kind of a balancing there, and in Wissink it was not done properly. You had a question?
Is the concept of Breger syndrome and Stockholm syndrome, is it admissible? Is it held? Does it pass Daubert or anything?
Well, that's really more of a criminal law question, because we don't really deal with that in the family courts. It has passed it. It has, but again, my concern with it is, as much as I've seen cases where it's been used properly in like justification cases and self-defense, that often in family court cases it's used against the parent, because it's basically you're saying that they're so helpless and so battered that they can't protect themselves. How do we expect them to protect the kids? And so it gets into a Nicholson kind of case. So then we get back to these standards again, and we kind of take it away from that syndrome, which is really more for criminal cases, and think more holistically here. Other questions? Okay. Well, I thank you, and I hope that you have a good next couple of days, CLE. And this is available in your materials, and if there's ever a question that comes up, you're always free to email me. John has my information, and so good luck to you.